going live. We're going to attack this 80-page spring semester outline for real property. Part 3, transfers of land as opposed to involuntary transfers by adverse possession, zoning, and eminent domain. Chapter 8, the land transaction. And you can see I've drawn virtually something like a sort of timeline where there's sales contract, including offer, escrow, acceptance, and contingencies. The next step is investigate title, including survey, title search, title insurance. Third step, mortgage loan, deed of trust. Fourth step, property destruction, equitable conversion. Fifth step, closing, pay purchase price, delivery of deed, delivery of cession. Okay, cession. Great in this angle. Looks like I also recommended listening to Lauryn Hill in Zion. I've also given myself a couple notes about the midterm, what's going to be on it, easements, real covenants, equitable servitudes, taking and zoning, and creation, treatment, and assignability of real covenants, easements, and equitable servitudes. So, which are non-possessory interests. Perhaps we'll talk about that. Contingencies. We're going to start with contingencies. It's like the last part of the sales contract, according to my little table of offer, escrow, acceptance. And for example, sale of buyer's real estate, example, these are all contingencies. Okay, I remember these from the real estate contract. There's a contingency for the buyer selling their own property, for the inspection of major components, survey, mortgage contingency, for example, lender advances promissory note, marketability of title is a warranty, but it's also a contingency in a real estate contract. Title search, title insurance, deed makes up that marketability of title contingency. There's seller representations. Commonly done as a seller's disclosure. It involves questions to the seller in which they attest to their knowledge about zoning, building, fire, health code violations that have not been corrected, pending rezoning, boundary line disputes, pending condemnation or eminent domain, easement or claims of easement not in public records, hazardous waste, improvements without permit, improvements not part of tax assessment or eligible for tax exemption, special assessments, or special service area. Real estate contract comes after the contingencies. And on page 561, discussing damage to real estate or condemnation prior to closing. If prior to delivery of the deed, the real estate shall be destroyed or materially damaged by fire or other casualty, or the real estate is taken by condemnation, then the buyer shall have the option of either terminating this contract and receiving refund of the earnest money, or accepting the real estate as damaged or destroyed together with proceeds of the condemnation award, or by insurance payable as a result of the destruction or damage, which gross proceeds seller agrees to assign to buyer and deliver to buyer at closing, Sellers shall not be obligated to repair or replace damaged improvements, and the provision of the Uniform Vendor and Purchaser Risk Act of the state of Illinois shall be applicable to this contract except as modified by this paragraph. So clearly what I've done is just quote whatever they excerpted and put inside the book, whether it be in a case or just a sample contract. So next page, these are not double-sided, and eventually they get to be about like double space, but for now we're not. So the next part 3, is the parties. Present mortgage gets paid off, real estate broker's commission, traditional sub-agency, legal fees, title search, title commitment, auto title insurance policy, closing by third-party escrow agent, mortgagee of purchase money mortgage, municipal fees, transfer tax, homestead act, insurance, dash homeowners, and the seller. That's all within the parties section. So what I've clearly done here is like read the book summary of what a real estate transaction is and just took down some buzzwords. The contract of sale, statute of frauds, background from 1677, no interest in land could be created or transferred except by an instrument in writing signed by the party to be bound thereby. No action shall be wrought upon any contract of sale of lands unless the agreement upon which such actions shall be wrought or some memorandum of note thereof shall be in writing and signed by the party to be charged therewith. There's a little bit excerpted from there, or extracted from there. The minimum requirements to memorandize agreement is to identify the property, signature of the parties to be bound, and state the price or the methodology of determining the value. Exceptions: leasehold, less than 3 years. Par performance, page 570, allows the specific enforcement of oral agreements when particular acts have been performed by one of the parties of the contract, for example, taking possession, paying all or part of the purchase price, and making valuable improvements. That's all true. But the thing that needs to be known is what 2 of 3 of those have to be performed. Not just one, not all, I think. 2 out of 3, but maybe I'm wrong. Money damages, usually not sufficient remedy, and knowledge on the part of the injuring party has been a critical factor in quoting Hickey. Estoppel usually occurs when unconscionable injury would result from denying enforcement of the oral contract after one party has been induced to seriously change its position in reliance of the contract, or occurs when unjust enrichment would result if a party who has received the benefits of another's performance were allowed to rely upon the statute of frauds. Estoppel is a defense and originates in equity. See, we're already on page 4, so this is moving just a bit faster. Knowledge on the part of the injuring party has been a critical factor. Again, citing Hickey. E-sign, page 575. A signature, contract, or other record may not be denied legal effect, validity, or enforceability solely because it is in an electronic form. From Title 15 of the United States Code, Section 7001, A1. Section 706(5) defines e-signature as an electronic sound, symbol, or process attached to or logically associated with a contract or other record and executed or adopted by a person with the intent to sign the record. Now, marketable title comes up. circled. The page is marked, so get an idea. It's not very long because equitable conversion comes right next, but under marketable title, I'm saying an implied condition of a contract of sale of land is that the seller must convey to the buyer a marketable title. Example, title not subject to such reasonable doubt as would create an just apprehension of its validity in the mind of a reasonable, prudent, and intelligent person. One which such person, guided by competent legal advice, would be willing to take, and for which they would be willing to pay fair market value. Example, encumbrances, easements, real covenants, not zoning, and equitable servitudes. Commercial outline. Contracts contain an implied covenant that seller will deliver title free from an unreasonable risk of litigation at closing, for example, when purchase price and deed are exchanged. Zoning restrictions do not make a title unmarketable. It's highlighted here. I'm sorry, it's its own little bullet here, but I feel like I remember something different. So zoning restrictions don't, but like zoning violations probably do. For instance, my house is built 10 feet away from the curb, and houses are supposed to be set back more than 15 feet from the curb. Therefore, my property is in violation of the zoning, and therefore the title's unmarketable. I mean, maybe it's not, but I remember reading cases in which it said it was. And so, equitable conversion, page 580. If there is a specifically enforceable contract of sale of land, equity regards as done that which ought to be done. For example, buyer has equitable title from contract date, seller has legal title and holding, and trustee for buyer, which has the effect of protecting risk of loss. The risk of loss belongs then to the buyer or seller depending on jurisdiction. In Massachusetts, either party can enforce the contract and abate money for loss. English rule, seller does not have to remit, probably is what it says, remit insurance payment to buyer. That's according to maybe the U.S., or that is the U.S. minority rule, and then the American rule majority is the seller must credit the insurance proceeds to the buyer, who sustains the losses. So the duty to disclosure defects. Caveat emptor, let the buyer beware. Caveat emptor requires the buyer act prudently to access the fitness and value of his purchase and operates to bar the purchaser who fails to exercise due care from seeking the equitable remedy of rescission. Commercial outline. Duty to disclose patent defects known to seller must be material to be actionable. Objective test for materiality. Would reasonable person attach importance to defects such as impact home buying decision? Subjective test for materiality. Would buyer attach importance to defects such to impact their home buying decision? So, in other words, there's an objective test for materiality and a subjective test for materiality. But to bring an action for patent defects known to the seller, those must be material. Stigma statutes, that's what I was thinking about recently. Required disclosure of murder on the property for an occupant ridden with AIDS. That was an actual case. Although a recent story told by me is that somebody told to me is that somebody in the local area has to move into another apartment that's more accessible, and one of such apartments happens to be one where somebody was shot in the apartment, and so they're concerned about moving there because of the history of the person who lived there and was shot that others in the neighborhood told them about. So that's a stigma statute. I mean, there's statutes about it, but that's a property that has stigma. Hazardous waste. So the stigma statute requires the disclosure of the murder on the property or occupant who had AIDS. So the person potentially moving into that apartment should be hearing it from the person leasing them an apartment, not from the neighborhood. This case was real. It was a New York case, and the information was publicly known. It was published in like the Reader's Digest, and so the question was, if whose job is it to tell the buyer, like, if it's public information? Sales contract will be upheld if the defects are reasonably discoverable and there is no fraud. Fraud of different kinds listed here include intentional misrepresentation, negligent misrepresentation, innocent misrepresentation, misfeasance, and nonfeasance. I have no definitions except that it's on page 604. Innocent misrepresentation, that is. So negligent, intentional, those are kinds of misrepresentation. There's misfeasance and nonfeasance. Damages. Specific performance is rare. Equitable remedy when money damages are sufficient. Occurs if the seller breaches because real estate is presumed to be unique. Money damages under overriding rule cannot exceed the price by the grantor, received by the grantor. That's the overriding rule of money damages. And for example, the recovery for a claim against a warranty of cession, the grantor may return all or a portion of the purchase price, but there is no requirement to pay fair market value. Oh God, excuse me. Seller breach, restitution of earnest deposit money, expectation damages, lien, fair market value at breach, which I have in parentheses as sales price. So, example, recovery for a claim against a warranty against encumbrances includes the cost to remove if removable. If not removable, then the recovery equals the value of encumbrances less the value without encumbrances at the time of purchase. So what does that mean? It's interesting because we just went over an example, a hypothetical about this, where so-and-so didn't record a easement that they paid for to right away across another's land, and then there was a foreclosure on the land. They didn't see the easement. They didn't inform the person who was the holder of the easement. They sold it, or they bought it at foreclosure. They sold it to another party for like a huge profit, and then when they bought it, they saw that there was like this huge road that the neighbor was using pursuant to a easement that was like not recorded. So what do? It's so funny here, but one of the things that was not discussed, it's kind of like, what are the rights and remedies? But one of the things that was not discussed that could have been discussed was that the person who foreclosed could have just bought the easement, gave it to the purchaser, So they go to the neighbor and they say, yeah, you spent $500 for this right of way 30 years ago or 10 years ago. And now I want to buy that paper from you. I guess what we did in the essay was consider if they had a prescriptive easement. But here you got a realistic way of resolving this is like, I'm buying your easement. What do you want for it? They made like a $70,000, if not $75,000 profit on the property. And this guy's got a right of way that he purchased for $500. So I'm pretty sure you can make a deal there. And that example is probably more realistically what happens than arguing prescriptive easements after an easement wasn't recorded. And so where did I find that? Recovery for a claim against a warranty of cession. Okay, that's a warranty and shove. Okay, so so back to damages. Specific performance is rare. Money damages. The overriding rule is that it cannot exceed the price received by the grantor, which is a weird rule. What about a grantee? Does that not matter? I guess the grantor is the one giving the covenants, so that's why it matters. And they are saying here, recovery for a claim against a warranty of cession. The grantor may return all or a portion of the purchase price, but there is no requirement to pay fair market value. And then seller breach, restitution of earnest money, expectation damages, lien, fair market value at breach sales price. And so the example that I just gave is an example here. Recovery for a claim against a warranty against encumbrances, for example, the easement for $500, includes the cost to remove it, if removable, if the easement holder will sell it. If not removable, then the recovery equals the value minus the encumbrance less the value without the encumbrance at the time of the purchase. So therefore, if the neighbor won't sell their easement, then you have to reduce what you received from the buyer to basically compensate them for the loss in value of the property with the encumbrance. So this neighbor paid $500 for it. They won't accept $50,000 for it, which let's just say that's what it's worth. So you have to give $50,000 to the buyer who bought it for $80,000 because its true worth with the easement is $30,000. Oh, and there's a calculation right here. Purchase price minus fair market value plus consequential damages. Consequential damages. Okay, this is getting hard. Are not incidental damages. Just special damages. They're damages for what you knew. So if you sold to a place that a person who said they were going to build like a horse stable over the westerly side of their property, and now there's a right of way there that you can't abate, then they've got to maybe tear down a tree to put it in the backyard. And if that's the case, that tree removal that was unanticipated might be a consequential damage if you knew what they intended to use the property for, I think. Anyway, so purchase price $80,000 minus the fair market value, which is now $30,000. Gives you $50,000 that you're giving over to the buyer, plus consequential damages, which is like the $4,000, or $8,000 or $10,000 to remove trees, where they're now going to place the horse stable in the backyard instead of the side yard. Those are your plus the consequential damages. That's what that equals. So now you're talking, you pay the buyer $60,000. You rebate them that much. because you had an encumbrance against the property, even though you warrantied against encumbrances. That's how that would more realistically be resolved. After the holder of the easement argues they actually have by prescription now. Merger doctrine. When a buyer accepts deed, the buyer is deemed to be satisfied that all contractual obligations have been met. Merger doctrine. When a buyer accepts deed, the buyer is deemed to be satisfied that all contractual obligations have been met. The contract merges into the deed, and the deed is deemed final act of the parties expressing the terms of their agreement. Only warranties breach can be actionable on the seller, which can be contracted away by the parties except for fraud or misrepresentation of material fact. Only warranties breach can be actionable on the seller, which can be contracted away by the parties except for fraud or misrepresentation of material fact. So there's different kinds of warranties. I'm shocked that I don't have it here. It'll come up. There's like present warranties and future warranties or something like that. The present warranties are going to not survive after the deed is provided to the buyer. But the future warranties will. Here they go. Okay, we're about to get into them. So let's just say the present warranties are the covenants of cession, the covenant of right to convey, the covenant against encumbrances. And then you've got a covenant of general warranty, a covenant of quiet enjoyment, and a covenant of further assurances, and a covenant of present covenants and future covenants. So I was right about the terminology. So those present, one of those ones that are labeled present, they get, quote, merged into the contract, and so they don't survive after a deed is conveyed. But future warranties, they do. And so the seller is required to uphold covenant of further assurances and the covenant of quiet enjoyment. They got to make that right after after settlement, after the deed is conveyed. So here we are on a new page. Implied warranty of quality enforceable on new homes against a builder or merchant. So that one's special. The deed, warranties of title. Fiafment with livery of cession. I just wrote that within a section called timeline. So the deed, warranties of title, timeline. So this all begins with the fiafment with livery of cession. From the statute of uses of 1536, enables conveyance of legal title by bargain and sale without livery of cession, delivered deed to solicitor's office. And then came in the timeline the statute of frauds, 1677, abolishes livery of cession and instates requirement of written instruments for conveyance of an interest in land. Several kinds of deeds morphed into one modern deed. That's what I've got. Is no longer as part of the timeline, but as part of something different. But within warranties of title. Is that several kinds of deeds morphed into one modern deed. Example, by these presents the grantor does give, grant, bargain, sell, remise, devise, release, and convey unto the grantee and his heirs and assigns forever all of that parcel of land described as follows. So those are words of grant. And there was a lot of them. Now you have warranty, at least within warranties of title, you have warranty, warrants against certain defects in title. General warranty deed is a deed that warrants title against all defects in title before or after the grantor took the title. See how I said before or after the grantor took the title? Those run with the land to grantees, successors, and interest. They also allow a successor in interest to bring an action against I forget the terminology for the grantor before this grantor. Maybe like a previous possessor or something like that. I don't remember. Quitclaim deed. It'll come up. We use terminology regularly. A quitclaim deed, no, a special warranty deed is less protection. It contains warranties only against the grantor's own acts, but not the acts of a previous possessor. A quitclaim deed, lastly, has the least protections. It contains no warranties of any kind, and it conveys whatever title the grantor has, if any, and the grantee cannot sue if he takes no interest. The warranties of title, I gave the names of them before, and I'm going to define them. I believe what's present, there's 3 present, at least 3. And you get the covenant of cession, which is that the grantor warrants that he owns the estate that he purports to convey. There's the covenant of right to convey. The grantor warrants that he has instances. This covenant serves that same purpose as the covenant of cession, but it is possible for a person who has cession not to have the right to convey. For example, a trustee may have legal title, but be forbidden by the trust instrument to convey it. Third, a covenant against encumbrances. This is the last one that I know to be a present covenant, and so the grantor warrants that there are no encumbrances on the property. Encumbrances include, among other items, mortgages, liens, easements, and covenants. Fourth is probably not either present or future, and it's not even really talked about all that often. It's called the covenant of general warranty, where the grantor warrants that he will defend against lawful claims and will compensate the grantee for any loss that the grantee will sustain by assertion of superior title. And I think that, it would clearly only apply for a general warranty deed. It wouldn't be the case of a special warranty deed or a quitclaim deed. The covenant of quiet enjoyment, the grantor warrants that the grantee will not be disturbed in possession and enjoyment of the property by assertion of superior title, often merged into the government of general warranty. Okay. A covenant of further assurances. Grantor promises that he will execute any other documents required to perfect the title conveyed. Like in the conveyance between seller and buyer, if there's anything wrong, seller does sign a form that says that he is going to do what's in his power to correct that defect. Present covenant broken if ever at the time the deed is delivered. For example, the grantor either owns a property or not. A statute of limitation begins to run at the time the delivery of deed. A future covenant runs the land to all successors in interest of the grantee and can bring a cause of action. Present covenants have no similar treatment, and then the statute of limitations begins to run on the breach of covenant in future. Jurisdictional extension of warranties to remote grantees. Majority, remote grantee cannot sue a remote grantor. So these are the words I was looking for. Successor in interest, but remote grantee, remote grantor. That's probably the best word to use. Minority rule in the jurisdictional extension of the warranties to remote grantees is that a remote grantee can sue a remote grantor, but the majority does be the opposite, that they cannot sue a remote grantor. A case I recall, and it's written here, is Rockefeller versus Gray. Then you get to what we discussed on page 604, which is innocent misrepresentation. A representation of material fact made for the purpose of inducing the purchase. The representation is untrue, and there is justifiable reliance by the plaintiff on the representation by the defendant, and damages are incurred. Recording. I'm going to stop here for recording. It's a new section.